I'm very privileged to be here and be able to exchange a few thoughts on the Consumer Protection Act 2019. Legal topics can be quite heavy and boring, and it is my endeavor to keep it as conversational as possible and not burden you with too many technical aspects of the law, the various provisions in the Act, and the various concepts which would actually help you to understand the kind of rights that you have. If I may just take you back in time, the last Consumer Protection Act, the previous avatar, was the Consumer Protection Act of 1986. Now, we got independence in 1947 and the Republic was in full force in 1950. But then you can imagine for 36 years, you really did not have a Consumer Protection Act as such. There were of course, other laws, but they were absolutely beyond the reach of the ordinary consumer. And the more important aspect is the enforcement mechanism, that is the judicial infrastructure that is required to uphold the rights of every consumer, was woefully missing. And even after 96 Act came into force, it has been a long journey. And it is only now on August 9th, 2019, that the new Consumer Protection Act has come into force. And it is hoped that all the lacuna, all the drawbacks, and all the disadvantages that manifested in the previous Act of 1986 are remedied, and hopefully in real time, consumer rights will be upheld and consumers will have access to redressal of their grievances. So let us hope that this new Act will again actually help all consumers. The timing of the Act, unfortunately, has been such that between August and March, some kind of a progress took place, but after that, because of the pandemic, the whole world has gone into the virtual mode, and therefore even the consumer protection mechanisms, the various forums that are available for consumer protection are also in the virtual mode, and it will take some time before we are able to resume normalcy and people have greater access to the various forums that will uphold consumer rights. Next slide, please. So the main objective of the Act is to establish the Central Consumer Protection Authority. It was considered necessary there should be a monitoring body which will in real time address various issues that actually concern consumers and take corrective action and safeguard and enforce the interests of the consumers. So the Central Consumer Protection Authority is not a judicial authority. It is a central authority in charge of consumer affairs. And the objective of the CCPA is to make sure that there is an effective redressal of consumer disputes. That means establishing various forums for enforcement, like the District Consumer Forum and various other forums, and to protect the consumers in the age of online trading, because consumers are invariably exposed to a number of risks when they actually do online trading, particularly people like me who are not very tech savvy, and we end up making a mistake here and there. And of course, to make sure that consumers are not misled by false advertising. So the Consumer Protection Authority is actually charged with the duty of upholding consumer welfare. So broadly speaking, what are your rights? The right to safety. You buy a product, you must make sure that the product is safe for your handling, your operations, your use. And you need to have all the information about the product, and you have the right to be informed. There is no question of assuming that you are supposed to know. There's a right to be heard. That means if you have a grievance, you have to be heard about your grievance. Your complaint should be taken seriously, and a response must be given to you. There is a right to be heard and the right to choose. If you have a couple of options or 2-3 options, you need to know that there are options. If you have a right to choose, that means those options should be presented to you. It is not as if you choose something and then you find that your friend got a better deal somewhere. So the right to choose is an extremely important aspect of making an informed choice as to what you really need. The right to seek redressal, to be able to go to a forum, that is Consumer Redressal Forum, and have your grievance redressed by filing a complaint. And that right is now given to you. It was there in the 1986 Act, but it has been given in a much more crystallized and a much more enforceable way under the 2019 Act. And of course, you have every right to consumer awareness. That means all the manufacturers and service providers must provide you as much information as is important for consumer awareness. Every right which I have listed here has a corresponding duty. If you handle a product properly, there's a duty to handle the product in accordance with the manual or the instructions given to you. And when you have the information, if you don't understand, you are supposed to ask as to what it means. So with every right that I have listed here, there's a corresponding duty, and you need to make sure that you are inquisitive, you are interested in asking questions, and you must make it a point to know more about what is being told to you. This is the most important development that the 2019 Act has brought in, product liability. As you know, product safety and product liability are very important concepts, particularly in the US and various other Western countries. If you have gone through the papers and seen the class action suits that are brought against various manufacturers, right from the tobacco litigation to medicine litigation and various other, for example, the cancer drugs, all those product safety and product liability actions have resulted in multi-billion-dollar damages. So the product liability in India was originally considered that if you buy something, you are supposed to know what it is. And more importantly, if at all there is a liability, the liability was rather in monetary terms limited to the amount that you paid for a product. Or at best, you are entitled to have the product replaced if it is not functioning properly. But now, product liability has been enlarged to provide that if a manufacturer or seller sells a defective product, the defect can be latent or patent. If it is on the face visible, for example, damage, you can easily say that, well, it looks damaged, I would like the whole thing to be replaced. But not everything is visible. The problem of product liability is more to do with latent defects, defects which cannot be seen by the naked eye, but which can manifest in the course of operation or use of that particular product. So the manufacturer is now made to compensate the consumer for the injuries caused by the defective product. Please understand that whenever you make a claim, you need to support your claim with documentation. If you have gone to a hospital, if you have taken treatment, if you have taken medical investigation, you need to make sure that you keep all of that, including the report prepared by the doctor, because the consumer forum would want to know as to what kind of evidence you are producing in support of your claim for product liability. So record keeping is extremely important. And remember one famous thing: all legal battles are won by the person who keeps the maximum records. Paper trail is extremely important. The kind of correspondence that you have with the manufacturer, the answer you get, or the answer you may not get at all. Every step of it, you must make sure you keep those records in a file, properly filed in a chronological order, so that when you go to the advocate or when you file a case yourself, you are in a position to sequentially present your case with support to documents at every stage. So make sure that you keep records of everything right from the purchase cash memo till such time you have actually gone through this entire process of getting treatment for any product liability issue. So in a condition for product liability, in this case, you can file a complaint at the relevant consumer redressal forum. And you could say that there has been a manufacturing defect or the design of the defect is defective and the product deviates from manufacturing specifications because what is said in the leaflet is something different from what the product is actually. And of course, the product does not conform to the express warranty. For example, people give that this is very safe to operate under these conditions, but when you operate, it actually doesn't work or it may result in some kind of a damage. And therefore, the manufacturer is held responsible for failure to live up to the promises that he makes through various leaflets and various sales literature. And the product does not contain adequate instructions. People may say that you did not instruct. In fact, in the past, if you see, whenever something went wrong and if you complained, the manufacturer would say, well, our service outlet is located in Kengeri. So it is your duty to bring it all the way to Kengeri and we are happy to deal with it. Where is the happiness? I don't know. But this is the way manufacturers and dealers used to behave. But now it has become extremely important for manufacturers and dealers to realize that they can be in real grief if consumer complaints are not taken seriously. Next. So this is just an example of if a microwave explodes due to defect and injures a consumer, he or she can claim compensation from the manufacturer of the microwave oven for the extent of injury caused. Under the 96 Act, as I mentioned to you, the manufacturer had to only compensate to the extent of the price paid to the purchase of the microwave oven. There could be anything. It could be a pressure cooker, safety valve going off and then hitting somebody's face. Anything can happen. So product liability is extremely important. Like I mentioned to you, it all depends on how well you actually maintain a record of everything, because at the end of the day, the record will actually help you win a case. Next, please. The Consumer Protection Agency is also given the power to recall unsafe products. As you all know that now and then you will come to know that Toyota recalled a particular model because the fuel injection system was wrong and a particular model was recalled world over or particular region. In fact, the use of the power of recalling was seen in the Food and Safety and Standard Authorities. In fact, Nestle was recalled about 30 tons of Maggi noodles was recalled from the market because it was found that it contained excessive levels of lead, making it unsafe for consumption. So it is quite possible. In fact, if you all remember, there was also the question of Cadbury's chocolate, which is supposed to have had some insects, and even Mr. Amitabh Bachchan had to eventually come and say it is safe to eat. And so there's a celebrity reassurance given and saying that the chocolates are safe to eat. But nevertheless, that industry went through quite a few anxious moments before actually the dust actually settles down. So it's extremely important to know that the products that you get are absolutely safe for consumption. I may pause here for a moment and say that there is a very important enactment called Prevention of Food Adulteration Act. It's an extremely important act, and it has got a big index of all the products and the various standards it has to comply with. And every food inspector can actually take samples and actually he can then subject it to test by a laboratory. And then if it is found to be adulterated, then it can actually lead to a lot of problems. The significant problem being sometimes the directors can be held responsible because the Prevention of Food Adulteration Act is very, very strict in terms of punishment. They say 6 months imprisonment or a certain amount of fine. And imprisonment becomes compulsory in the case of proven food adulteration. And under the Food Adulteration Act also, there is a provision for consumers to actually make a complaint if the food was found to be adulterated. But the consumer has a lot of uphill task in maintaining various records because he has to get the product tested by a laboratory and then get the statistics and then go. He would rather go under the Consumer Protection Act, in which case the consumer forum can decide to direct the product to be tested by a laboratory. So it's much easier under the Consumer Protection Act than for the consumer to take it upon himself under other enactments to prove a case. Next. Medical negligence. This is something which happens in different parts of the world. We have seen a lot of things happening. Medical services fall under the purview of consumer protection, and courts have increasingly clarified that medical treatment rendered to a patient for a certain amount is a service for the purpose of Consumer Protection Act. The Consumer Protection Act protects you from two important aspects. One is the goods and the second is services. So if there's a deficiency in service or somebody refuses to render service after having paid for it, that also comes under the purview of the Consumer Protection Act, both goods and services. So if a doctor prescribes a medicine for gastric problems, the patient complains of chest discomfort, and they say, oh, this must be some gastric problem, and he prescribes a medicine rather than referring the person to a cardiologist, then it could actually lead to a claim under the Act for medical negligence. And when unnecessary surgery is performed due to misdiagnosis, I've come across cases where a patient is actually forced to take a single room, paying about 17 to 20,000 rupees per day, when in fact other rooms are available. And they gave various excuses and make the person take that room because they did not want that particular room to go unoccupied, because everything is a revenue proposition at the end of the day. And the more revenue a doctor makes, the more importance he is given in that particular establishment. And so if the people should actually be very careful in making sure that all the medical records are kept, and you go for a second opinion to make sure that what was done was right or wrong. And if you feel that you are taken for a ride, you are entitled to make a claim under the Act. And you can then produce all these evidence in support of your case. Next, please. Misleading advertisements. In fact, you must have seen many advertisements. People actually put a small caveat saying that the product shown in the picture are not the exact image of the original product. So they make it, completely jazz it up and make it attractive and make it as if, that's one of the best product that you can think of. But when you actually get the real product in hand, the reality is something else, as this picture would show. So misleading advertisements can actually make people believe that they are getting a very good deal and they're getting a great product. But at the end of the day, they may be very sadly disappointed. Next, please. So the 2019 Act defines misleading advertisement. One is it falsely describes a product or service, gives a false guarantee, which is likely to mislead the consumer, conveys a representation, which would actually mean an unfair trade practice, and deliberately conceals important information. Now let's assume that there is an advertisement that if you buy this bottle of shampoo, you will actually get a 500 or 200 ml of conditioner free. No, it is an attractive proposition that you are getting something free when you buy something, because it's very common these days for people to get something free with every product that they buy. It's become a common thing. But if one goes behind the economics of such a particular offer, sometimes you find that the shampoo, which was priced, let's say, 150 rupees before the offer, the price actually is jacked up to 175 rupees, and then the free offer comes. So the offer is not really free. The offer has been subsidized by the increase in the price of the shampoo. So when a price increase has actually happened before a promotional offer is made, then the claim they make in the advertisements that the conditioner is free would be misleading and also would constitute unfair trade practice. So these are all the practices that happen, but one has to actually see as to what is it that you paid. Because if you are a person who has been buying a particular brand of shampoo, you typically know how much that shampoo would cost. So when you actually get this free offer, you will then pause to think, hey, I paid 150 last month. This time it is 175, and then I'm getting this conditioner free. That means the condition is not really free. So you can come to your own conclusion in such cases. I'm just giving one example. There could be many products which qualify for the same test. If deliberately concealing important information, for example, edible oil advertisement gives the impression that you are free of heart problems as long as you're using that particular oil. I mean, this claim has been made by many people. But if the manufacturer makes such a statement, which is absolutely incorrect, then it can actually lead put the manufacturer in real difficulty. A consumer can file a complaint at the relevant redressal commission against a manufacturer for any misleading advertisement which deceives and harms the interest of the consumer, or a cumulative complaint can be filed as a class to the district collector. So extremely important that you exercise your right either individually or collectively. So celebrity endorsers, all of you know that different film actors and various celebrities actually promote a whole lot of product. In fact, yesterday I was looking at one product where Salman Khan is advertising that you get a 1.5 liter bottle of Pepsi for 50 rupees. So like that, there are many people who actually endorse various products. But please understand, earlier on, endorsement was a money-making proposition. Just a question of lending a face. In fact, people would actually use the face of a celebrity, and the celebrity would not even know that next to his face, a lot of words are put around, glorifying a particular product. And at the end of the day, it would appear that the celebrity is actually saying all of that. That becomes an endorsement attributed to that celebrity. So celebrities must be extremely careful. In fact, all the actors and celebrities have agents who are publicity agents. It is these publicity agents which can actually land them in trouble if they are not careful about the endorsements that carry along with the face of the celebrity. A manufacturer or even an endorser of a product, such as a celebrity, may be required to pay a penalty of 10 lakhs, which may also extend up to 50 lakhs if it is found that the entire advertisement was misleading and the endorsement was made for money without even having used that product. So if a person actually says that this particular oil is actually going to help me, grow my hair, the person may not have used it also, but he endorses. That means he's endorsing something which he doesn't believe in. So that would mean misleading. Not only the advertisement is misleading, but the celebrity is misleading the consumer. They may be prohibited from endorsing any product for a period of 1 to 3 years, depending upon the extent of contravention. So celebrity can have a loss of face. So we have an example, an athlete endorses an energy drink stating it will provide extra stamina, but he should have verified the same by consuming it. Otherwise, he can not only be guilty of misleading the consumer, but it can actually result in somebody taking a drink which will be full of steroids and may have serious adverse effects. So it is a very dangerous game to endorse the products without actually verifying the correctness of the statements that are attributed to the celebrity. These are the two examples of trouble brewed for cricketer MS Dhoni over his association with a very unpopular real estate group called Amrapali. And a lot of FIRs were filed against Mr. Dhoni. And Mr. Dhoni for having endorsed that particular project called Amrapali Centurion Park and all that. The matter is still hanging there, but that shows that celebrities must be extremely, extremely careful that endorsement is not a money-making proposition anymore. Endorsement can be serious business. Similarly, Mr. Shah Rukh Khan, all of you know Fair and Lovely and all those things. Besides being what we call body shaming, this has become a very big issue that you are discriminating fair people and and dark people, and it has become a very sensitive issue. In any case, the fact remained that Delhi court imposed a fine of rupees 15 lakhs on the company, Imami, when the Fair and Handsome cream failed to make the complainant fairer in 3 weeks, as the advertisement actually claimed. Though, of course, the consumer said that it was bought on the advice of Mr. Shah Rukh Khan, Mr. Shah Rukh Khan himself personally was not involved. Of course, I must mention to you that these two cases happened before the 2019 Consumer Protection Act came. It happened under the 1986 Act. E-commerce, extremely important. World has changed, and COVID has made everyone rely on online purchases, online trading, and even people who are not tech savvy in the month of February had to learn the hard way as to how to use a computer and how to use a tablet and how to get on to download a particular app and then order something and then make payment. Everything people have learned. In fact, necessity is the mother of invention, the oft-repeated statement. But the 2019 Act requires e-commerce entities like Amazon, Flipkart, anybody. It could be Nature Basket, it could be Big Basket, it could be IKEA, it could be anything. They must provide all the information before the consumer can make an informed decision. If you look at Amazon for that matter, may I stay with the slide, please, the previous one. If you look at Amazon, if you go to a particular product, you actually click, you can look at the size, you can have the explanation. There will be some brief explanation also given to you about what that product is all about. There is enough information for you to actually buy the product. And the most interesting that Amazon or Flipkart or anybody else does is a return policy, in the sense that if you are not satisfied with the product, or if it is of a wrong size, if it was not something which matched the picture that you saw, what you got is completely different from what you saw, then without any questions asked, you are entitled to return the product. That's the kind of protection that the manufacturer or service provider himself takes to avoid any further confrontation with the consumer. And for me, consumer is now at an advantage of being able to decide what he wishes to have, what he wishes to return. And that's an extremely important right that is given to the consumers. So we should spend a couple of minutes on this mandatory information from retailers. All these online purchases that you make, all the people who are e-tailers, they must give all these information depending upon the nature of the product. What is the delivery charge? What is the product's total price? Are there going to be any handling charges? Is there a product expiry date? Is there a grievance officer given? Because I would like to know, if at all there is any problem, I should know whom to talk to. So if there is a grievance officer's name and contact details, what are the available payment methods? Can I pay by Google? Can I pay cash on delivery? What are those informations about payment? Product's country of origin. Okay, you have actually advertised something, but you're not telling me that it has come from China. Because right now, I'm not in a mood to buy anything from China. But if after receiving the product, I find that it is made in China, I'll be very upset. It's such a waste of time. So besides my being entitled to return it, I can also make a grievance that you have not given the basic information about the origin of the product, from which country it originated. It's a breach of duty on the part of the retailer not to disclose the origin of the product. And of course, how guaranteed is the gateway of the payment? There are so many gateways. Are you assuring me that the moment I enter my credit card, I put my CVV and I put my OTP, it is not going to be snooped? If somebody is not fishing for that information and actually misusing it, and by the time I conclude the deal, the rogue would have completed 3 more deals. Is your payment gate secure enough? Are you assuring me it is secure? And are you taking responsibility if there is some breach of that security at your end? Do you have a complaint tracking number? When I make a complaint, you need to make sure that the complaint is registered. You are supposed to send me a text message or a WhatsApp or an email. Then there should be a tracking number. I know that the complaint is being followed up, and it is not a complaint which is forgotten the moment it is received. So it becomes a huge responsibility for people to actually track the complaint. They also track delivery. The moment you place an order, you get an SMS or an email saying that it is under process. When it is discharged, when it is dispatched, another message comes, it has been dispatched. And then sometimes they even give you an OTP, which you are supposed to give to the delivery boy before the delivery boy can actually deliver it to you. And of course, there are various terms of exchange and refund. You must clearly mention as to what I can exchange and what I can refund. And also, when I want to exchange, when I want to return the product, what are the precautions that I must take? Should I even keep the plastic cover outside? Should I keep the carton? Should I keep something else that came along with the product? So you must educate me. You must tell me in what condition I should be returning the product the way which was delivered to me, whether the package also should be delivered, the various outer packet. You should tell me what you want me to do. I'm happy to do it, but it's your duty to tell me how I must actually return. So a number of duty have been actually cast on all the e-tailers, and I must say that most e-tailers are actually following this, particularly the big e-tailers like Amazon and Flipkart and IKEA and all those people. But I'm not too sure about smaller e-tailers. There you should be careful about getting this information or asking for this information if that information is missing. Please understand, ladies and gentlemen, there is a famous saying called caveat emptor. Caveat emptor means buyer beware. It has always been the case, buyer beware. Even today, despite all the protection that you are getting under the Consumer Protection Act, it is your alertness, it is your seriousness, it is your quick thinking that actually helps you protect that right that you have been given under the law. Law cannot be expected to protect you in vacuum. It will protect you provided you give the kind of evidence or show the kind of diligence that you are supposed to exercise while purchasing a product. That will help in actually enforcing the right that you have under the Act. Next, please. Unfair trade practice. It's all about, like I mentioned to you about the shampoo and the conditioner. There are many unfair trade practices people actually follow. It's extremely important for you to know whether you are being forced. In fact, if you look at this popcorn picture, you'll be reminded of you being charged or compelled to buy mineral water in a multiplex cinema. You went there for a 20 rupee bottle. You may have you were required to pay 50 rupees or 70 rupees, depending upon the kind of rent that the retailer is paying, perhaps. But then a rule came that you cannot force people to buy water after having confiscated the water bottle at the frisking gate. You must provide free drinking water, and that's how we are able to get free drinking water these days in all the multiplexes. These are all considered as unfair trade practice. So extremely important for you to know that Next slide, please. Extremely important for you to know that you have a right to file a complaint before the consumer redressal form. Please understand, like I mentioned to you, like all records, a bill or a cash memo, if it is not issued, even that becomes an unfair trade practice. You must have seen these days, people make these very interesting statements. If you ask for a bill, if your bill is not given, the purchase is free. But that doesn't happen. That just shows that you are expected to get a bill and you will get a bill. If they don't get a bill, the particular outlet says the purchase is on me. Of course, they just take comfort, but they do give a bill, and that shows that you are able to actually. I would like to mention one important thing: how important it is for you to maintain a bill or a cash memo, because that is your evidence of purchase, and that is your evidence based on which you can actually make a grievance if something actually goes wrong. Particularly when the seller refuses to take back defective goods. And that is when you need to make sure that you file a complaint. In fact, it should be 30 days within the date on which the bill was given. If the bill was given like the first of the month, you have 30 days within which actually to make a grievance about it. Or in some cases, people have written exactly there, no refund, no replacement, no exchange. So you buy with the condition. So you cannot make a grievance later on that there is no refund or there is no exchange. But please understand, even in those cases, if you have bought something, for example, a dress, and the color runs, the very first wash, it runs, and the bill says no refund, no exchange, that becomes an unfair trade practice, because you know jolly well that it is an implied warranty that when I buy a beautiful bright red dress, that red color is not supposed to run. And you sell me something and the color runs, and you try to hide behind that particular legend in the bill, no refund, no exchange. And that becomes an unfair trade practice. So it becomes something which the court will frown upon. And the other aspect is the manufacturer or service provider represents himself as a consumer and posts reviews on products to mislead potential consumers. So they themselves post a lot of testimonials as if it is a review by 10 people. If it is found out that the manufacturer or service provider is actually providing some, praising himself, posting certain testimonials, making it appear that the customers have posted it, then also it becomes an unfair trade practice. Next. Unfair contract is extremely important. As you know, way back in DLF case in Delhi, Gurgaon, Supreme Court came down heavily saying that developers of building cannot simply hold customers responsible by relying on those small prints, putting conditions if the customer doesn't even have the ability to read, or even if he reads, unable to understand. So an unfair contract is where one party, that is a manufacturer or servicer, actually benefits and the customer is put to disadvantage. In other words, it's called the customer tripping. So you trip the customer by making him sign. Now today, all of you are used to clicking the button, I agree, without even reading the terms and conditions of a website or an app. But that has become more like a habit, a mechanical thing to say, I agree. But how many people do have patience to actually go through the contract and see if there is something unfair to the customer? So the Consumer Protection Act 2019 has actually brought in this concept of unfair contract, where you are required to provide excessive security deposit. You go to a bank and you want to actually open a safety locker, and safety locker is available or made to look as if it is being made specially available to you, provided you give a 1 lakh rupee or 3 lakhs rupees fixed deposit. Now that, according to the act, is an unfair contract, because there is no quid pro quo between the service and you are having to deposit a certain amount of money which has no connection to it. Similarly, you are required to pay a penalty which is not proportionate to the loss occurred due to the breach of contract. And the trader unilaterally terminates the contract without reasonable cause. So the question is, whenever you find that a particular deal or a particular condition is unfair, you are certainly entitled to question that, because that puts you at a disadvantage. Next. Grievance redressal, you have below 1 crore, you can file a complaint in the district commission. Between 1 crore and 10 crores, you can go to the state commission, and 10 crores and above, you can even file at the national commission. In fact, 1 crore has been made a big difference to people, particularly the common people, because earlier on, it started off at about 20,000 rupees, and then it became 2 lakhs, and now the limit is absolutely fantastic, up to 1 crore of rupees. You can go to the district commission. Within Bangalore, you can file a complaint before the district commission. And of course, if an appeal lies to state commission and a further appeal lies to national commission, and if national commission you are unhappy with the decision, it can go to Supreme Court in certain cases. So right up to the Supreme Court, you will have the ability to redress the grievances. Next. So the procedure to file a complaint, it would be interesting for you to know. I will take a few minutes to go through these steps, extremely important for you. Send a notice to the manufacturer or seller. This notice should inform the intention to take action for receiving the defective goods or defective service. And it is an attempt for settlement between both parties. So the notice does one thing. It gives the opportunity to both parties to settle the matter and not let the matter go to court. So notice is extremely an important step. You must make sure that you also enclose a scanned copy of the cash memo or scanned copy of the document that you have. For example, if it is an AMC contract, so make sure that you have the AMC contract, the whatever payment you have made, the cash memo, and also copy of the contract. You can scan and attach it to the notice that you are going to send. And then you look at the choose the commission, depending upon where you are. In earlier on, you had to file a complaint where the manufacturer is. Now you can file the complaint where you are sitting. So there is no reason for you to chase the manufacturer. The manufacturer can be brought to the place where you are. So choose the right commission. If it is Bangalore, there will be a district commission in Bangalore, which you can actually file. And before that commission, you can file a complaint. And if you look at the seller or manufacturer, when he refuses to compensate, you can actually file a formal complaint, and you can make it the basis for claiming a compensation. And the compensation should be claimed not by a number that you pick from the hat. It should be seen as something which is reasonable, something which you can actually support with some evidence, and you can file the complaint. And have all the documents ready. Like I mentioned to you, documents win the case. Have all the documents ready. Bill, receipt, record, online booking, warranty card, everything. Make sure there is no scrap of paper which is not important. Everything is important. Keep it that way. And make sure you have all of that in order to support the complaint. And then you may have to file an affidavit. Affidavit is nothing but a sworn statement. You may make a statement before a notary public and attach it to the complaint to show that whatever you are saying under oath, and it is all true and correct, and you have not made any wrong statements. And all the statements that are made are true to you, the best of your knowledge and belief. The 2019 Act allows the consumers to file complaints electronically. And there is this website which I have given you, and you can actually log on to the website and actually file complaints electronically also, instead of going to personally to the consumer forum. Depending upon the type of the forum and the value of the product, a certain amount needs to be paid as a fee, but it's a very interesting to show that no fee is to be paid. No fee is to be paid for filing complaints where the purchase price for the defective goods or service was below 5 lakhs of rupees. That's a big margin. So virtually, the ordinary consumer need not really worry about paying any fee, court fee, insofar as if the amount involved is only 5 lakhs or less with respect to the price of the goods or price of the services. So extremely big difference it makes, because you don't have to worry about spending too much money like people may think it is spending good money after bad money. So it's a very accessible, efficient redressal, and I sincerely hope that when normalcy resumes, it will be possible for all the commissions to function full time, and the customer will be able to file. And if you look at the bottom of the slide, there is a video tutorial that is available for e-filing. Please see if you can spend some time going through the video tutorial for e-filing. The rules for video conferencing is of course awaited, but e-filing is available. Please go through the video tutorial, because that is something which you can sit at home and file a complaint and not really worry about chasing a lawyer or walking all the way to the consumer forum. And consumer can approve the commission at a place where you live, as I mentioned to you. And like the previous practice of having to go to the place of the manufacturer is no longer necessary. You can file it at the place where you live. Once a complaint is filed, consumer needs to wait only for a maximum of 3 weeks before you get an endorsement that the complaint has been admitted, and then the manufacturer will be issued a notice, and then it happens. Now look at this very important aspect is that retailers will have to have a grievance officer, like I mentioned to you. And once the complaint is communicated to the grievance officer, he or she is required to acknowledge the same within 48 hours. And the grievance should be redressed within 1 month. The most important thing that the Consumer Protection Act has done is mediation. Consumer forums where you file a complaint, they may themselves suggest that the manufacturer or service provider should actually come to some settlement with the consumer and not unnecessarily drag on the proceedings and burden the court. So at the appropriate stage of the case, the consumer forum will refer the manufacturer or service provider and the consumer for a mediation by consumer mediation cell. Mediation is not a process where somebody decides the case for you. Mediation is a process where you decide the case for yourself. Mediation is therefore assisted negotiation. The mediator does not sit as a judge. The mediator will talk to the manufacturer, talk to the consumer, understanding each other, and helps both of them to come to an agreement. That is why it is called mediation. Is an assisted negotiation where parties are allowed to decide for themselves what the dispute, how the dispute should be resolved. And the mediator does not decide anything. So that's the beauty of mediation. And you are not obligated, once you are referred to mediation, you are not obligated to settle the matter. If you find that the manufacturer is being unreasonable, even during mediation, you can go back to the consumer forum and say that the man is being very difficult. I propose many kinds of settlements, but is unwilling to agree to anything. So the mediation has failed. So let the consumer case continue. So you have an opportunity of going back to the consumer forum and continuing to prosecute your complaint, and you are not under an obligation to settle when the matter is referred to mediation. Of course, if it is settled, everybody is happy and people can go home after shaking hands. So we have come to the end of this presentation, and if you have certain questions, you can actually ask me, and my friend Madhav, who is also on the call, he's a senior associate of mine, and he's equally competent to answer this question.
the next question from Mr. Murthy. He says, when we buy products online from Amazon, most of the time the cash memo is on thermal paper and the letter fonts are really small, almost illegible. And many times seller details are also not properly printed on the cash memo. So in that case, is it the responsibility of Amazon or is the seller liable for warranty?
Thank you. That's a very important question and actually very relevant in the present time. Thank you for the question. And to answer that, it could be termed as an unfair trade practice on the part of Amazon. Because as was already mentioned by Mr. Prasanna, when there are certain information that are not provided by the e-tailer, such as this is something that is very important, because at the end of the day, an e-tailer like an Amazon or a Flipkart will have closer contact with the seller. And they have to make it their responsibility to make sure whatever information they get from the seller, that proper information is provided to the consumer as well. So at the end of the day, as the 2019 Act has stated, if that is the case, you can definitely file a complaint against Amazon or Flipkart.
So Mr. Rao has asked a question. He has given this instance. I filed a consumer case against BBMP regarding triple property tax collected without issuing receipts or accounting the excess payment. The consumer court sanctioned a compensation of 20,000, but BBMP is silent now. They're not honoring the court order. Is there any consumer association that can help me to file an execution petition against the BBMP?
Okay. Personally, I am not too, I do not know a consumer association, especially when it comes to BBMP. However, this would come under the ambit of probably any consumer association because it is a grievance at the end of the day and it has to be redressed. Basically what you could file is, of course, an execution petition against BBMP. Again, if they do not if they do not comply with their obligation, you could always go to the state commission again afterwards as well, telling them, because at the end of the day, the state commission can order BBMP much better. If you're not getting the proper redressal from the district commission, you could always go to the state commission on appeal and seek their help. If that also doesn't work, then of course you could always go to the national commission and get it done. So from what I can see is that it is a large compensation, and this matter would be taken up if it is seen that the BBMP has not been complying with its obligation.
Marjorie wants to know, can a complaint be filed if money is taken for providing a flat or a plot of land and no flat or plot is provided?
Yes. In fact, yes. So the Dhoni example that was provided in the presentation, that was actually involved Amrapali group of developers who had not given the flat as promised within a particular time. There were in fact consumer complaints filed against it. There were FIRs filed against Dhoni because the developer was not complying with its promise. So yes, of course, home buyers and also developers. So home buyers are also consumers under the Act, and hence you can file a complaint because this is a type of service under the Act.
Another question is, are the consumer courts overburdened with cases like the normal courts? And how do they ensure that the seller will abide by the decision of the consumer court in favor of the consumer?
Yes. So, of course, they are overburdened. I wouldn't say they're not, because there are a lot of consumer complaints, but they are actually redressed in an efficient manner as well. So maybe if it is a complaint which does not involve a lot of money, so in that scenario, they have something called summary proceedings, which basically means that they do not look into too much into the case. Once they find out it's apparent that there is a grievance here, that something really happened because of a defective product or a defective service, then they would actually fast track the process and have it settled as soon as possible. And in fact, even mediation has been brought for that right now, because they know that mediation, which is mostly out of court settlement, would make the redressal more efficient. So, so in that case, so mediation also has basically been introduced to make the burden a lot less for the courts. So we are assuming that moving forward, there will be less burden. And how to ensure the seller will abide to the decision? Well, at the end of the day, any decision that is eventually rendered by the consumer forum is in the same effect as that of a judgment by a court. So it is enforceable. It is very enforceable. So it becomes a law technically. And you can, once you have a judgment, once you have a decision by the consumer forum, you can go enforce it, and that has to be complied with. Otherwise, it would be contempt of the court's order, and they could be penalized for that as well.
Okay, that's great to know. And is there a time limit for filing a case?
Yes, so the current act says 2 years from the time when the cause of action. So cause of action is when the reason for the dispute has arisen, or reason for the redress, the grievance has arisen. So say if a microwave oven, so just like in the example, if the microwave oven has injured you because it's exploded because of a defective manufacturing, because of a manufacturing defect, then from the date that particular instant, that particular accident happened, the time starts running until 2 years. So within those 2 years, you have to file your complaint. So that's the limitation.
I see one more question from the same person. Doesn't an FIR have to be filed even if one approaches the consumer court when someone took money and didn't provide the flat plot as promised?
So again, a very good question. And in fact, that's something that a lot of us have. Even lawyers, for sometimes, we don't really know which case is civil and which case is criminal. But FIRs are generally filed for criminal cases. So you lodge a FIR for criminal cases. Now, if this particular developer has cheated you, has taken your money, has cheated you, has basically probably siphoned all the money and just ran away just by cheating you and misleading you, then of course an FIR can be lodged against the developer, because under section 420 of the Indian Penal Code, which is cheating, so which is defined, so they do come under that ambit, and you can file an FIR. Of course, if you are just wanting the compensation, so say you have paid for that flat, and at the end of the day, you do not really want a criminal complaint to be filed against the developer. Because at the end of the day, a criminal complaint is something you file against the state. So the state files it against you. So technically, the state will be filing it against you against the developer once you file a criminal complaint. So, so in that case, if you're just seeking the compensation, which is more of a civil case than a criminal case, then you could rather just go to the consumer court than also file a civil case, because the consumer court is a lot more efficient and you would probably have it redressed much quickly than if you go to a normal court. So even if it's a criminal complaint, some of the criminal complaints, if it is not seen to be too urgent or serious, they take a long time to proceed. So that way you could probably just go to the consumer court to get your matter redressed.